All right, we are here with Kara Martin from the Franchise and Business Law Group. We're here to talk about trademark basics with you today. But Kara, why don't you introduce yourself?
Hello, I am one of the attorneys and partners with the Franchise and Business Law Group. I have been with the Franchise and Business Law Group since 2009, so almost 11 years now. And my primary area of practice is franchise law, but I also focus part of that on trademark law. So all of our clients that need trademark work, I'm the one that handles it. And I find it a really interesting area of the law. I also practice right now out of our Kansas office in Olathe, Kansas. So I remote in and I service clients all around the nation.
Great, great. Well, thank you for taking the time to be with us. Okay,
Yes.
so we are going to jump into trademarks. Trademarks, I think, is an area where most people are familiar with what a trademark is, but a lot of people don't really understand much more beyond that. So we will jump right in. So the first question is, Kara, what is a trademark?
So a trademark, there are actually a lot of different types of trademarks, but essentially what it boils down to, it's a word mark or a design or a logo mark or a sound mark. Those are the three most common types of trademarks.
Okay, so we'll get into that. What is the difference between a trademark and a service mark?
So this is something I get asked a lot because you'll see people next a designation next to a word that is SM, and sometimes it's a TM. And essentially the difference is a TM is a trademark that designates a product, and the SM is a service mark that designates a service. In practice, most people are just putting the TM, but technically that's the difference. It's just one designates a product for the TM and one designates a service for the SM.
So if I was doing door-to-door windshield repair and I wanted to trademark my name, I would put an SM. And if I'm selling sweaters and I had a name, that would be a TM?
Correct, yeah.
Okay. So just going back to, you said word mark, design mark, and sound mark. So give me an example of what a word mark is.
A really popular, easy one to designate is looking at McDonald's because they have all three types of marks. So the word mark is McDonald's. They also have the word mark, I'm feeling it. And the design and the logo is the common symbol, the golden arches. They also have a sound mark in their little jingle. Da 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 da.
Oh, interesting. Yeah, you're right. Because you hear that basically after every commercial, at the end of every commercial.
And you can hear it and you instantly know who was making, what product. You don't have to be looking at the TV or having heard a radio ad. You hear that jingle, you know it's McDonald's. And so they want to protect things like that.
Right. Okay. So what you're saying is nobody else can use that sound.
Correct.
Okay.
And nobody can have a restaurant with golden arches or a restaurant that's called McDonald's.
Okay. Yeah. I think that's a good example because obviously everyone's familiar with McDonald's, and then to break it down like that to say what the difference is between those three things, that's great. Now, I am not a trademark attorney, so I don't know if this is true, but can't you trademark a color?
You can, yes. So that's also, that often falls under trade dress. But yes, you can trademark a color. It's really difficult. It has to acquire what's called secondary meaning, and I'll talk about that in a little bit.
Okay.
But basically, it means that the color alone, it's just like the jingle. When you see that color, you know exactly what company and what brand is associated with that and all of their products and or services. And so it can acquire a level of distinction that allows it to get trademark protection.
Cool. I've heard that T-Mobile, that pink color, that's the one that comes to mind that they've trademarked, that pink.
Yeah, there's actually, you bring up pink, and what's funny is there's actually quite a few pink specific trademark colors.
I'm sure, because lots of people want to use pink. Okay, so the next thing, let's get into, can a word, design, or sound get trademark registration? I mean, we talked about, I guess we're kind of coming back to that, but just talk a little bit more about that.
So typically trademarks fall into 5 categories, no matter what they are, whether it's a word mark, logo, sound, color, and it's either generic, descriptive, suggestive, arbitrary, or fanciful. Now, the first one of those, generic, you cannot obtain federal registration for it, and that's because that's the name everybody uses. And the reason you want federal registration is to stop other people from using that word or that phrase in association with the same or similar products and services. So it's a common name. So if you have a restaurant that sells tortillas, you can't call it tortillas because that will stop other people from getting, or excuse me, you can't have a restaurant that sells products. You want to offer that product under the name tortilla. And that's because tortillas are tortillas. And the USPTO doesn't want to stop everybody from using that word.
Okay.
Similar, it's also very difficult to acquire registration for a descriptive. And we can use tortilla as the same example, but that's where I mixed it up, and that could be the name of your restaurant, where it's a Mexican restaurant and you call it tortillas. Well, that's suggestive because at Mexican restaurants, typically you will find tortillas. So the USPTO has a hard time because they're saying, well, that just describes the product that you're offering. And again, if we stop everybody else from using that same word who offers the exact same product, we have a problem here. So they don't want to give expansive rights. So descriptive words are really difficult to register, but as I mentioned with color, you can acquire what's called secondary meaning. And secondary meaning is typically found after 5 years of use, and it's where you are so in the community that you've become essentially famous. And even though tortillas is a tortilla and it's sold at your restaurant, let's say you have 30 or 100 locations nationwide, all called tortillas. Well, at that point, you probably can show that the public, when they say, let's go to tortillas, nobody's thinking, I'm going to go to the store and get a tortilla. They're thinking of your exact restaurant and the brand. And so it's expensive to prove secondary meaning, but it's possible. The USPTO also recognizes that a lot of words are becoming descriptive. And so they have what's called the supplemental register. And I'm not going to talk about that other than to say it exists and it's for descriptive marks, but it does not have as many protections as the principal register.
Okay. So going along with tortillas, I would have a hard time probably naming my Mexican restaurant Tortillas, but if I were to have like a marketing company that didn't sell tortillas or whatever, and I wanted to get a trademark for the name Tortillas for something that had nothing to do with tortillas, would I have a better chance of obtaining registration?
Absolutely. And so that gets into the next 3 types of trademarks that are more easily or most likely going to get registration. And that would be an arbitrary mark. A really common type of a really commonly known arbitrary mark is apple. Apple, we all know what an apple is, and it's a fruit, but we also associate the word apple with computers, phones, MP3 players, all of that. And so it's arbitrary, just like tortillas is. Tortillas have nothing to do with marketing, but you can use that name in your marketing company because it isn't associated with it. It takes a leap of the imagination.
Yeah, yeah. I like that you're using very common examples because everyone knows, oh yeah, Apple. And then, oh yeah, that's a computer company. So yeah, I think that's a great example.
Yeah, and so for the other one, like I said, the last 3, suggestive, arbitrary, and fanciful, they all require the consumer to take a leap of imagination. They have to associate the brand. It takes some imagination, some thought required to associate. So suggestive marks, it requires that leap of imagination to associate or determine the nature of goods or services in question. And so a really common example of this one is Greyhound. And while people don't travel by bus lines anymore, for the most part, Greyhound still exists. And Greyhound is suggestive of the services. It isn't arbitrary. It isn't found to be arbitrary because a Greyhound dog is sleek and it's fast and it moves. Similar, that's what Greyhound bus lines want you to think of. It's sleek, it's fast, it moves, it transports you. And so Greyhound is both a dog, but it's a registered trademark as a suggestive mark for bus transportation. And then the last mark is a fanciful mark, and this is one that's a completely made up word. Think Kleenex. Everybody uses Kleenex. That did not exist. That word did not exist for tissues before Kleenex. Same with Xerox for copies. So these are, as a trademark attorney, fanciful marks are the favorite marks because there's no reason to not get registration. Nobody is using it. Nobody's heard of it. But I know as business owners, they dislike fanciful marks because now you have to spend so much more in marketing.
Because you got to teach the public what it is.
Exactly. I mean, this is why businesses tend to move towards descriptive marks, because it describes exactly what it is. So you don't have to teach as much to the public to get it out there. But when you're trying to build national recognition, really you should stay towards suggestive, arbitrary, and fanciful marks.
It's great. Great. And do you come across clients that have a name that they're using and they want to get trademark registration, and you say, hey, listen, you're going to have a really hard time registering that name because it's too generic, too descriptive, and now's the time to change the name?
Yeah, I have that conversation actually more than I would like. And the thing that is hard is you've built this business, or this brand, you have this idea, and you really have become, it's sort of like your child. You don't change your child's name just because 100 other kids have that same name in the school, but you aren't trying to market your child, and you are trying to market your business or your product. And so it really is important, if you get the advice back from an attorney saying, this is going to be hard to register, it is probably, my advice is always spend the money up front before you've grown too big, before you are really well known. Change your name now, because then you can bank off of knowing that from the beginning you have a mark that the public can associate, and you will not have to change it. You won't be in fights. And ultimately that's a cheaper course of action than down the road fighting to protect your name, to keep your name, stop other people from using it, and all the problems that can come with a generic and a descriptive name.
Yeah. Pay me now or pay me later.
Yeah, exactly.
It's a good saying. So, okay. That's really, really helpful. That was great. All right. So why is a trademark important? Why go through all the hassle to try to get a unique name that you can register?
Well, it's your brand. That's what sets you apart. It creates for the consumer and the public a link to your service or your product. An example is, if I say the word soda to you, that's a generic word. What can come to mind? Probably anything from Coke to A&W root beer to Mountain Dew, depending on where area you live in, Shasta, anything. But if I say the brand Nike, what do you think of?
Athletic shoes, sports gear, very specific. With that swoosh, I think of the swoosh.
With the swoosh, exactly. Okay. So you think of a specific brand, and that's the power of a trademark. That's the power of branding. You want the public, when you say the name, that they think only of your business, of your products, of your services, all associated under that brand. So it's not like soda, it's more like Nike.
Okay, that's great. Okay, so there's, from what I understand, there's you can get protection, obviously through registration with the federal government or a state government. But are there any other protections? Like, let's suppose I've had a name for 10 years and I just haven't ever gone through the hassle of calling an attorney. I shouldn't say the hassle, never taken the appropriate steps to call an attorney to get my name registered. Do I have any protection to the name if someone else tries to use it, down the street?
Yes, you do. And yes, don't think of calling an attorney as a hassle. It's a protection. Yeah. So to answer your question, that's called a common law trademark protection. And everybody who creates something that is unique and not already registered, you have common law protection once you start using that product or that service in association with the name or the logo. So simply being the first to use a trademark, you all automatically get rights within the region or territory that the trademark is being used. And those rights begin the second you start using the trademark. A business owner may have exclusive rights within your region to utilize the identifier in the sales, marketing, production, or other aspects of the company. And so what you want to look at is, so you've been using your mark for 10 years. What areas are you in? And you find out, or you get most commonly what happens is you've been using your mark for 10 years or 20, and you get a cease and desist letter from an attorney. And it says, we have the federal registration, stop using the name, well, we'll sue you. And that scares people. Sure. But then you have to step back and realize where you have been using your trademark, as long as it was before the registration happened. And there's some nuances here. So this is just your very baseline Trademarks 101. But where you've been using it, you have protections. So let's say you have a series of restaurants in the state of Nebraska, and you are in 7 locations throughout Nebraska, and you're known there, and you've been operating as XYZ services. Okay. Then somebody registers XYZ for the exact same or pretty similar services to you, and you get a cease and desist letter. Well, get an attorney, and that attorney will help you understand and protect your rights in Nebraska, or at least in the territories where you are currently. So you don't have to change your name, you don't have to change your branding, you're protected. And that's automatic, so long as somebody wasn't using it in the same territory before you, or didn't have federal trademark registration before you.
Okay, so in theory, someone out there could have been using the name Burger King well before the main Burger King used it and registered it. And if they were using it and Burger King came down and said, hey, stop using our name, it's like, hey, I've been using it before. I can't expand my use of it, but I can keep using it as I am.
Correct. Yeah. And that's an important distinction. You can't expand then beyond where you have been, or where you can demonstrate you had a current growth plan that you were instituting. But you don't have to change where you are. And a common brand that some people may know of is the restaurant, the Egg and I. Yeah. Well, they have federal registration for Egg and I, but there are other pre-existing Egg and I's around the country. And so those Egg and I's that are mom and pop restaurants, they got to keep their name. And in those areas where the franchise Egg and I wants to go, they actually have a separate name that they operate under in those regions.
So I wonder if that's why it was Hardee's and Carl's Jr., I believe, are the same company, but they, depending on where you are in the country, they use a different name. Maybe that's why.
Possibly. I think that might have been 2 companies merged, but I don't know.
Oh, okay. All right. So what would be the importance of, I mean, what are some pros and cons with common law trademarks?
Well, common law trademark, you get to automatically put the TM or the SM next to your word mark or your symbol, your logo, and you can let the public know you claim trademark. You get protections in that region. But what you don't get is national protection. So your rights extend only to the areas where you're operating or you're doing your business. You are not listed on the principal or supplemental register with the USPTO, so nobody really knows you exist when it comes to somebody else claiming they have first rights. Right. And there's no presumption of ownership. You're open to challenges. You now have to prove when you started marketing. You have to prove your expansion plans. And so that's a big burden that you have to prove if you want to move beyond. Let's say you get that cease and desist letter. If you want to continue expanding, now there's a level of proof that you have to provide that is just presumed when you have federal trademark registration.
Okay. All right, that's good. So a lot of times I'll see a name, and you had touched on it saying, okay, if I got common law protection, if I haven't registered yet, I can use the TM. And then sometimes I see the circle R. What's the difference?
So it just is exactly that. TM is all trademarks that are just under common law. So it's either a state trademark, state registered trademark or just a common law trademark. And the circle R is reserved only for trademarks that have registration on the principal register with or supplemental register with the USPTO. So it's gone through the process of registering the mark. And when you see that, you can basically know that if you see a mark that has a circle R, you know that they are going to claim federal and national protection. So you can't mess with that mark, essentially. So there's that presumption of exclusivity, presumption of first use. So a lot of great things come with the circle R.
Okay. All right. And so sometimes I do a lot of entity, organization, corporate law stuff. And sometimes people, when I say, hey, you ought to speak to Kara, she does trademarks, and because you should register your name. And they say, oh, well, I've already got my name. I registered the name, XYZ LLC with the state of Utah, and that's my entity name. So isn't it registered?
Yeah, that's actually a really common misperception. And that's because when you register an entity, the state checks to see if there's another entity. And so a lot of people presume that because they checked that and there's no other name operating with that same name, that they have now the trademark rights. And that's just simply not true. A federal registration actually can stop an entity registration. So sure. If I have my business XYZ, or let's say my business is Bob's Barbecue. Barbecue's big here in Kansas. And so let's say I have my Bob's Barbecue LLC. Well, if I haven't checked and I open up a restaurant, it's doing really, really well here in Kansas. But lo and behold, 15 years ago, somebody registered the name Bob's Barbecue. Well, now I have to change my name. Just because I was able to get an entity registration in Kansas doesn't mean that I can use the name. States don't check the principal register.
Right. So that trumps it.
It does.
Okay. And so maybe, you talked a lot about advantages to the federal registration trademark. It sounds like you just get a whole lot of protections when you have a federal registration.
You do. You have an arsenal of protection for you, and you can go after people to bolster the strength of your brand.
I like that, arsenal. It's a good word. Okay, what about a trade name? What's the difference between a trade name and a trademark?
So a trade name it's the best way to think is it's the larger company. It's the larger company that identifies perhaps a lot of smaller companies. So everybody's probably familiar with SC Johnson. That's the trade name for the larger company that owns brands like Glade, Pledge, Windex, Baby Ganix.
Okay, interesting.
And so a trade name, that's typically how we think of in the trademark world what a trade name is. So it's sort of the umbrella company, and you can register a trade name because it's a business and it's a brand identifier. But typically it's going to hold a bunch of other companies or other products that it's identified by.
Okay, yeah, that's good. Okay, so then you had earlier mentioned trade dress when we were talking about colors. Like what is trade dress?
So trade dress is essentially the look and the feel of the product or the service. It's most commonly associated with products. So again, if we look at a really common trade dress, it's the design of the Coca-Cola bottle. Okay. No, it's a very unique and distinctive design, and it's called the trade dress. So the way it slopes, it comes in and out and up, and it has certain markings in it. That's the trade dress for the Coca-Cola bottles. And so anything manufactured by Coca-Cola will have that same, whether it's Coke Zero, Diet Coke, or Coke, it's going to have that same look on the bottle. And no other bottles look the same. And you can also, so that's product packaging, and trade dress is most often associated, but you can also do it in the overall design and appearance of, let's say, your restaurant. So In-N-Out Burgers has a very distinctive trade dress. You go in, the colors are clear, the layout of the restaurant is really clear, and that's trade dress. And the US Supreme Court has actually come down years ago and laid out exactly how trade dress gets protection, whether it's for a product or for sort of the layout. And it also has to meet, I talked earlier about the sort of secondary meaning. It has to have acquired a distinctiveness and a secondary meaning. And it also excludes functional portions. And so, like on the bottle, the Coca-Cola bottle, you have to have a cap on it. And so the cap portion, unless it's a distinctive cap, that's functional. The fact that a restaurant has seats, it's alone, is functional. And so it has to be distinctive, it has to be unique.
Okay. And do you have to register for trade dress protection, or you just get it?
You just get it again, but it's really hard to enforce. And you can register for trade dress protection. You can get a federal registration for trade dress, but you have to prove that secondary meaning.
Gotcha. Okay. Very interesting. Okay. So, well, we've got a few minutes left. I want to ask you a couple questions that I'm sure our audience is dying to know. Like, what is the cost to register a trademark?
So costs range all over the board, but typically, if you don't use, you most often have to use an attorney these days. Some rules have changed, but so there's two types of filings, two main types of filings with the USPTO. One is called a TEAS Plus, TAES, and the other is TEAS Standard. And TEAS Plus is $225 and TEAS Standard is $275. And that's just the fee to the USPTO.
The filing fee.
The filing fee. Now attorneys will charge an additional fee if you use a third-party research group to do trademark clearance. That's an additional fee. So you typically are going to be looking at, in the range of, depending on the service you use, anywhere from $600 up to $1,500 per registration.
In third party or attorney's fees or third party fees or whatnot.
In addition, so your total outlay will be between $600 and $1,500. $1,500, I've only heard of in a couple of instances. That's a really expensive trademark, but I have heard of that.
Okay, great. So how long does it take to get, once you file, how long does it take to get registration?
Generally 9 to 12 months, but it could be longer, generally not shorter. And so you apply, you submit the application, and it actually just sits there for 3 to 4 months. You can see it online, but nothing happens to it for almost 4 months. And at the 4-month mark, it's assigned to an examining attorney, and then they move the process along, where they either issue an office action or they move it towards publication and registration. And then there could be an opposition filed. So on the speedy end, it's 9 to 12 months, but I have one client and we've been waiting for registration for almost 4 years now, just because of issues that have come up all along the way.
So when you say it just sits there for 4 months, what's the purpose of that?
It's just backlog.
Oh, I see.
It's because it just is, the examining attorneys are so busy. There's so many trademarks being filed every day that they just don't have the capacity to get to all of them. So it's just a backlog.
Backlog, makes sense. Okay. And then you had touched on saying nowadays it's getting more complicated. You almost need an attorney. And why is that? What are the rules that have changed?
So the rules that have changed is on a TEAS Plus, on that $225 application, you have to use what the USPTO has set out in the manual. So you can't create, when you apply for a trademark, you list your goods or your services. And like me, I like to be creative and I like to expand on what that is, kind of throw in what the possibilities are. But the USPTO has also given very generic descriptions. So if you use a TEAS Plus filing, you have to use the USPTO's descriptions. And because of that, the USPTO wants you to use an attorney so you get the descriptions correct.
I see.
If you use a TEAS Standard, any individual can apply, but then they have to name a US licensed attorney. And that's so that if there is an issue with the application, an attorney who's been trained in trademarks will be able to respond appropriately to the office action.
I see.
So these days, it used to be that anybody could file any trademark, and these days you actually need an attorney at some point in the process.
Okay, good to know. Good to know. Well, this has been super informative. If you have any parting words for our audience?
No, I think, if you're out there and you're thinking of a new business or a new product, try to remember the suggestive, arbitrary, and fanciful. And be creative. You've already been creative and you coming up with something unique that is your product or your business. And your name should reflect that creativity. And you can create branding to go along with it. And also don't be afraid to call an attorney. Anybody can call me and I will talk to you for 15, 20 minutes for free and talk to you about your trademark and tell you my thoughts, how long it'll take to get registered. So take time to at least speak to an attorney before you move forward and spend all the money on a name or a logo or something that is your product. Just take that time because it's going to be well worth it, especially if it's a free consultation. Very well worth your time spent.
Indeed. Okay. Well, thank you, Kara. Appreciate your time. Great information. And listeners, I would say take advantage of calling Kara. She's very experienced and would work hard to protect your brand.
Yeah, I appreciate this, Christian.
Okay. Thanks, Kara.
Okay. All right. Bye-bye.